The case to come before the court is Divis versus Divis.
Good afternoon, Your Honors.
Good afternoon. You have 15 minutes.
Thank you. If someone can let me know when there's about 3 minutes left, I'd appreciate it.
You're not going to be, there's nobody arguing on the other side.
I know.
But you just want time to wrap up. Okay, that's fine.
Yes.
Sure,
and
no
I want
problem.
to make sure that I relate to one issue
Okay, thank you.
especially. Thank you. My name is Jerry Pizak. I represent Brad Divis, who is the appellant in this matter. The incident that occurred that gave rise to the Divis CPO happened during a family cookout on September 7, 2015. There were a number of family members there at the cookout, but the four that testified were Amanda Divis, who is the petitioner in the appellate, Dorothy Divis, who owned the house where this occurred, Brad, who is Amanda's brother and the son of Dorothy. Dorothy's also the mother of Amanda. And then the last sister was Lauren Cromothel, and she's a sister of Brad and Amanda, and Dorothy is also her mother. And Kristen Divis, who was and is Mr. Divis's wife. So those are the four people that we have who testified in this matter. The incident, as I stated, occurred at the home of Dorothy Divis in Brunswick, Ohio. Amanda Divis and her 3 children were living there at the time of the incident. The magistrate in the trial court made certain findings which we are arguing and we believe do not constitute, if the court looks at, when the court looks at the testimony of the record, do not constitute domestic violence. The trial court found that the petitioner presents credible testimony regarding her reasonable fear of imminent harm and future acts of domestic violence by respondent. Petitioner testified credibly regarding respondent's history of domestic violence, including acts against his wife. For instance, petitioner testified she was contacted by respondent's wife for support in relation to a number of incidents of domestic violence by respondent, including an incident that resulted in respondent urinating on his wife. Kristen, in her testimony, disputed almost all of Amanda's testimony. She said that she called Amanda over when Brad and Kristen were having verbal arguments. Such arguments never arose to any kind of violence. Brad never touched her, never laid a hand on her, never harmed her, and she also said that she was not afraid of Brad. This is Kristen that we're talking about. She stated that she did call when she had a verbal argument. She would call the police because of the verbal argument. And she also called Amanda to come over to have someone to talk to. The fact that Amanda came over to Brad's house under those circumstances is proof, in our opinion, that she wasn't afraid of Brad. Because
what was the time frame between the Labor Day incident and this alleged incident at Kristen and Brad's home?
It was sometime in the past. My recollection was about 3 months, but my recollection on that is kind of vague. Okay. Well, I'm glad that you have the same recollection, Your Honor. The next finding of the court was that the petitioner also testified respondent had previously parked his vehicle behind petitioner's car and refused to move his car to allow petitioner to leave. Petitioner testified respondent hit her vehicle with his vehicle in order to prevent her from leaving his property during altercations previous to the events leading directly up to her filing. Your Honor, or Your Honors, this event evidently occurred about 2 years prior, and there was no evidence that Amanda was harmed, and Brad stated that that's not the way it happened. As a matter of fact, Amanda backed into him. She was drunk, and she threw food all over her mother's house. Evidently, there was some kind of a food fight after this incident. And nothing like that happened since. So this was a past act, which in and of itself, as the case law states, would not justify a present finding of domestic violence. There was also a finding that petitioner...
Excuse me, counsel, couldn't those past acts, though, inform the court and the victim as to fear, as to when he makes comments and so forth? The courts always look at the past acts, not necessarily individually to maintain that there's, domestic violence or stalking or whatever it may be.
Yes, Your Honor, I agree that the past acts would be taken into account to determine whether the present fear is reasonable. Mm-hmm. So to that extent, I do agree, but it was 2 years prior, and nothing like that had happened since.
Thank you.
And then following up with that point, Your Honor, the magistrate did find that petitioner credibly testified that respondent has physically threatened her. And that testimony seems to relate to, or that finding seems to relate to Amanda's testimony where she stated, and I quote, "Yeah, he told me I was good as nothing, good as dead. I'm worthless. I mean nothing." Now, this statement was disputed not only by Brad, but Lauren, who was there, never heard it, and Dorothy, who was there, never heard it. But interestingly, they have heard Amanda make similar comments to Brad about him being good as dead, and some of those comments related to Brad's children as well. In fact, a few weeks prior to the September 7, 2015 incident, Amanda sent Brad a text when she said, "You, your wife, and kids are all dead to me, F you all." Now, Amanda said that that wasn't a threat, and that it had absolutely nothing to do with being a threat. And that may be true, but it shows how words can be taken out of context. And I do cite in my brief where taking the words in context is obviously very important, especially when you have a statement, "good as dead." But that should be taken into account along with the other words that were stated. And basically what it appears Brad was trying to say, if he said that, and again, that's a disputed statement that only Amanda heard. If he said that, basically what he was saying is that Amanda was a worthless person. Disrespectful? Yes. Is it something a brother should say to a sister? No, never. But it is not domestic violence. The magistrate also finds that on multiple occasions, Brad refused to leave the petitioner's residence, which she shares with her children and the party's mother, despite petitioner's repeated demands that respondent vacate the residence. And also, respondent is unwilling to acknowledge that petitioner has any rights in relation to her current residence. The residence is owned by Dorothy. And Dorothy never stated that Brad should stay out of that premises. In fact, she wants him to be there. She wants his children to be there. And that is very clear from the testimony. Also, Brad and Kristen had called the police, the Brunswick Police Department, and asked about the situation. The Brunswick Police Department stated that Amanda has no right to control Dorothy's home because it's Dorothy's home. And it basically, if Dorothy wants them there, they're permitted to be there. The next finding of the court regarded the specifics of the confrontation on Labor Day, where the magistrate said that petitioner had told respondent to leave the resident and respondent refused. That's not true. The respondent, Mr. Divis, went to the property, got his son, went back outside into the car. He and his wife were leaving, and at that time, Amanda sent a text saying, "You are no longer welcome at the property." Then he went back to ask his mother about the text, not to confront Amanda, but to ask his mother about the text. At which time, Amanda became upset, and she, at one point, tried to hit Brad. Her testimony went both ways on this. On the one hand, she said that she tried to hit Brad, but she missed. And another point, she said that she had tried to hit Brad, and her other brother stopped her. But in any event, Brad said that he was punched in the face. When he was punched in the face, Kristen heard this event. She called Brad, and Brad said, "I just got punched in the face, call the police," which is what occurred. And it's interesting that both Lauren and Dorothy back up Brad's testimony as to him being hit in the face. In fact, Lauren said that Amanda went after Brad, and I guess it was with some force because Amanda's leg flew up and her shoe flew off when she went after Brad. And again, both Lauren and Dorothy confirmed Brad's version of what had occurred. The magistrate also makes a finding that neither party was charged at the time of the police involved, and I'm not going to read that whole finding, it's pretty long. But basically, Brad decided when the police came that he wasn't going to charge his sister. He then thought about it some more, and then he called the police, and he then did charge her. He had recalled that he charged her with domestic violence. But as the testimony went on, he later recalled, oh yeah, I think it was actually disorderly conduct. And Amanda admitted...
Counsel, you know, the victim doesn't get to choose whether charges are filed.
In this case, that's what happened.
Well, that's what the testimony was.
That is the testimony, Your Honor, and the police report would indicate that there were no charges filed at first, and then in the police report it indicates that Brad actually called the police and asked for the charges to be filed.
I understand. I understand what is in the briefs, but I'm just wondering how that transpired. That's all.
I understand.
Go ahead.
And I understand that it would be unusual because once the police get there, they make the decisions. But in this situation, it doesn't appear that that was the case.
I'm sorry, I've been listening and talking and asking questions. So you're at 2 minutes. I don't know what you want to say to the court, but you needed that time.
Okay, thank you, Ann. The last issue that I raised was that the court had abused its discretion in expanding the scope of the domestic violence civil protection order to preclude Brad from possessing, using, carrying or obtaining any deadly weapon, and from using or possessing alcohol or illegal drugs. The case I cited is a case that the court is familiar with, which is FS versus PASIC, and basically it says that these additional restrictions must be equitable and fair. We are arguing that the PASIC case, the FS versus PASIC case, is analogous to this because there is no evidence in the record that alcohol or drug use or abuse by Brad Divis contributed to the conflict between the parties. Alcohol was never mentioned at trial. The only drug that was mentioned is when Amanda said, this happens when Brad does not smoke his marijuana. So, which is a 180 way of looking at that situation. Likewise, there was no evidence in the record that Brad Divis ever used or threatened to use a deadly weapon to harm any protected person in furtherance of an act of domestic violence. there were references to firearms and whether or not Brad disregarded the firearm provision. The evidence showed that he did not, that he gave up his guns, and that, his wife, Kristen, picked up a gun from Dorothy's house. The evidence was that Brad did not pick it up, although the trial court found that Brad had retrieved the gun. And again, that's just an error by the court because that did not happen.
And counsel, your time is up. Thank you very much for
Thank
your
you.
presentation to the court. The court will take the matter under advisement and issue a written opinion, and also we will send we'll send it to you, and then we'll also release it on the website.
Thank you very much.
Thank you.
Have a nice day.